Good afternoon, everyone. I'm not sure. Good evening for some people, perhaps. Good afternoon for others. Good morning for others. Here in Cyprus, it's 5:03 p.m. and it's dark almost already. And I think we can start the webinar, and we will be letting people in as soon as they ask for admission. So you can see my slides, I think, yes. So thank you very much for being with us, everyone, distinguished guests, participants, colleagues, and students. So on behalf of the School of Law of UCLan Cyprus, but also the Larnaca and the Famagusta Bar Associations, from which you will hear after me, it's a real pleasure for all of us to welcome you here this evening for this training webinar held at the end of 2022, partly in celebration of the World Anti-Corruption Day, but also the Human Rights Day, that are both celebrated in December of every year. And we wanted to mark that before the year ends. This is the fourth in a series of CPD, Continuous Professional Development webinars, co-organized by the School of Law of UCLan Cyprus, the Larnaca and the Famagusta Bar Associations to celebrate the signing of the Memorandum of Understanding between the university and the Larnaca Bar Association and the Famagusta Bar Association, respectively. In a nutshell, these two MOUs provide an official framework for the collaboration between the university and the local bar associations in the areas of research, innovation, and applied experience in the broad field of law. To that intent, this collaboration further facilitates and promotes the dissemination of high-end knowledge and know-how to the members of all three institutions involved, including the students, researchers, but of course also legal professionals, so that they may enhance their strategic position with respect to law, compliance, ethics and integrity, rule of law and justice, and each within its own areas of expertise. So we are very particularly happy to be able to do this tonight. These MOUs are further evidence of our long-standing mutual commitment and relationship and can only enrich all of us. Areas of collaboration include the coordination, the co-organization and the mutual support of events, competitions, trainings, internships, and other professional educational activities, as well as awareness raising, capacity building, and wide dissemination of expert outputs. So tonight ticks quite a few of the boxes. To celebrate the signing, we had decided to have a series of related CPD activities during 2022, and tonight's webinar is the last outcome of this excellent cooperation for 2022. We are happy to continue the excellent cooperation in 2023, but I leave it to Christakis to agree or disagree. So I would like to warmly thank our distinguished speakers, everyone, all are very fine legal practitioners and scholars, and I thank them for their willingness and enthusiasm to speak to us tonight despite their busy schedules. Also, I'd like to thank all of you, the participants, as well as colleagues who have worked on today's event across all institutions. It's a pleasure and honor to be able to engage with so many of you, so many participants, including students, alumni, academics, professionals, as well as the wider public. Before I continue, please be reminded that this webinar is recorded, as you can see. This is for the purpose of widening access to educational resources, and you have been requested to consent to this. So I will please ask you to keep your cameras off and your microphones off, and to use the chat function in the MS Teams classroom to ask questions and make comments. We will be monitoring. If you do not wish to appear at all on the recordings, then do not use the chat function either. Can I please also remind all of you that each speaker and other participants who will take part in this webinar are doing this for educational purposes in an educational setting, That means that each participant will provide whatever each participant will provide verbally, electronically, or otherwise, but must not be accepted or interpreted as either legal advice or any form of advice. You may view materials at your disposal in the MS Teams classroom, and you are free to take them away with you and use them with the necessary acknowledgements. Subject to the professional background of each of you, participation may contribute to your formal or informal CPD or personal development or other self-management or self-managed learning and development needs. Specifically for Cyprus registered lawyers, you have been asked to provide your registration numbers so that we may report your CPD points for this webinar on the CBA platform. It is necessary, however, to attend most of the webinar to collect the hours, the 3 hours. Let me turn to tonight's topic, which is on anti-money laundering, legal practice, and the rule of law. And the focus will be on a critical post-Brexit Anglo-Cypriot analysis, which forms part of the fundamentals in the CPD portfolio of the School of Law, in association with legal and other practitioners, such as tonight. Judging by the number of participants tonight, which is quite healthy, the topic appears to be of ever-growing importance to legal professionals as well. Hence, the emphasis placed by the Larnaca and the Famagusta Bar Associations on the topic, and we thank them for this. For the past few years, the School of Law has been organizing knowledge transfer, knowledge exchange events around the rule of law, compliance, but also AML, dispute resolution, ethics and integrity on a regular basis in the form of seminars, conferences, public lectures, trainings, and other online activities. The online format has proved to be particularly helpful for professionals to join us, and we're very happy about this. Every time we have tried to ensure free and open access to educational resources emanating from these events. That's why I invite you here on the slide that you can see to check our website, as well as our newly established Jean Monnet Center of Excellence on the Rule of Law and European Values, CRoLEV, which contain quite a lot of open access resources, also of relevance to professionals. So please make notes of those 2 URLs, which you can visit as you wish. Turning to tonight's event, I'm very privileged to welcome, in order of appearance, Mr. Christakis Mouskos, President of the Larnaca Bar Association, who will also address us on behalf of Mr. Stavros Mavromatis, President of the Famagusta Bar Association. Then we will have talking to us for quite some time, Dr. Klearchos Kyriakides, Senior Visiting Fellow at the School of Law of UCLan Cyprus, and last but not least, Mr. Christian Pelaghias, Associate Lecturer at the School of Law of UCLan Cyprus. The rich bios appear in the flyer, and I would like to refer to you to the flyer rather than enumerate the long list of achievements, not only in Cyprus, but internationally. So a warm welcome to all our speakers. Now, a few words about what you will hear tonight. With all the speakers, we are very happy to bring you this webinar tonight because it's so timely in the context of a war, of a global pandemic still with us, and in the context of various scandals, even to the heart of the European Union. The primary aim of the webinar is to provide participants with information and insights into recent developments in the field of AML, and how this can impact your work as legal professionals in Cyprus, the UK, the European Union, and internationally. The webinar format is very convenient because it provides opportunities for participants to engage in discussions with the panelists about current issues and practical approaches for addressing the issues arising from these matters through the chat function, but also during the Q&A session. So each long session will be followed by a Q&A session. Please make use of it to engage with the speakers. Our speakers will develop matters of relevance to AML and financial sanctions in England and Wales, and their impact in the Republic of Cyprus in the first session. as well as issues of AML, beneficial ownership, transparency, and fundamental rights, such as the right to privacy in the Republic of Cyprus and the EU in the second session. These sessions are extremely timely, taking into consideration the latest case law of the Court of Justice of the European Union of direct relevance here. I mean, only in the past couple of weeks, we've had 2 cases that are of direct relevance to tonight's webinar. And of course, the latest developments on the AML Directive number 6, the new forthcoming AML Directive, currently being negotiated at the EU level, which is of high relevance to current issues of transparency and disclosure of interest. So I would like to thank all of you for being here and for providing us fresh analysis and insights of very hot topics, whereas they are still being developed. Without further ado, let me call on Mr. Christakis Mouskos to give us his opening statement. Thank you very much, Christakis.
Thank you, Stéphanie. Thank you very much. I think you covered everything, so I will keep it short, as always. Dear colleagues and dear students and participants, on behalf of the Larnaca Bar Association and the Famagusta Bar Association, I would like to welcome you all to today's webinar, which is co-organized with UCLan. I'm very glad that since the co-signing of the MOU, as Stéphanie has mentioned before, our corporation is established and has developed, and we hope that in the future we will manage to deliver to our members, the students, and the public even greater things. It is a very hot topic indeed. It is very crucial for professionals to be fully aware of the anti-money laundering laws, the regulations and the directives, since in our professional capacity we will have to deal with matters that fall into the legislation. We have numerous changes, and as you mentioned before, the new activities being discussed, and we will have to always be updated as the anti-money laundering field is constantly developing and updated, because it has to meet new challenges or new types of financial crimes. And I believe that these seminars are a very useful tool in our hands, in all professional hands. The AML, it's a sector that the last few years is developing so much that a lot of our colleagues are only the sector, and actually they're only working with the AML. It's a profession in our days. It's becoming a profession of its own. I would like to thank the speakers for their presentation, which I'm sure that are worthy of your attention. And I wish everybody good listening. And I hope that our cooperation will continue in 2023. Thank you very much.
Thank you, Christakis. With great pleasure, we shall continue our cooperation. I think this is to the mutual benefit of everyone, like tonight. So without any further ado, let us pass on the floor to our colleague, Klearchos. Klearchos is going to paint a quite detailed picture of the post-Brexit anti-money laundering and financial sanctions regime in England, and how this affects lawyers in the Republic of Cyprus. So Klearchos, the floor is yours. Thank you so much. We can see your presentation, all good. You've got an hour maximum. We look forward to listening to you. Thank you.
Thank you very much, Stephanie. I begin by expressing my thanks to the university and to the 2 bar associations for kindly instigating this evening's webinar. I also thank everybody who's worked very hard behind the scenes to put it all together. I need to explain at the very outset that the mindset behind there's a terrible echo. Am I being heard, or is the echo at my end? Can I just double check?
Yes, Christakis needs to mute himself. Okay, I muted him. Good. Sorry, Klearchos.
Thank you very much. So at the very outset, I have to emphasize two things. The first is that as I teach my students, the phrase anti-money laundering is the phrase that has become prevalent in professional circles for understandable reasons, but it's a problematical term. It's problematical because it focuses at the second part of the picture. The second part of the picture being the laundering or the alleged or the suspected laundering of dirty money, criminal property, stolen money. It diverts attention away from the first part of the picture, which is to do with the crime and the associated activities which have given rise to the criminal property, the dirty money, and so on. So what I want to emphasize from the very outset is that I have adopted the term anti-money laundering, but in doing so, I've done so reluctantly and subject to the caveat that I've just emphasized. In other words, one of the key messages that I want to transmit in this lecture is that every law firm, every lawyer, and indeed every one of us needs to have not just an anti-money laundering mindset, but an anti-crime mindset. The second thing that I want to emphasize in the introduction is that this gave me some difficulty when I was preparing the title for this presentation. I've used the phrase post-Brexit anti-money laundering and financial sanctions regime in the singular in England. In a sense, there are two separate regimes running in parallel with one another, not just in England, but in other parts of the world, including the European Union. The two separate and parallel regimes are the money laundering regime on the one hand and the financial sanctions regime on the other. And that's why I've used the term, I haven't, however, used the term regimes in the plural. I've used the term regime in the singular. And that is because even though governments, regulators and others tend to refer to the anti-money laundering and financial sanctions regimes in the plural, they are in a sense two sides of the same coin. So what I want everyone in the audience to sort of have in mind is that the mindset that I'm bringing to this presentation, my mindset is built around anti-money laundering and financial sanctions being two sides of the same coin, and therefore they jointly create one regime. And within that framework, of course, one finds other subsets, such as counter-terrorist financing, such as anti-fraud, and so on. So with those preliminary remarks in mind, let me move on. I acknowledge some of the Crown copyright and other copyright materials that I've used. There's my standard disclaimer. I'm not providing legal advice in this presentation, and everything that any views that I express are purely mine and not those of the organizers or of any other organization. A quick declaration of interest. As things currently stand, I have a foot in the two camps. I have one foot in the United Kingdom, where I was born and of which I am a citizen, and I have a second foot in the European Union as a citizen of the Republic of Cyprus, by extension a citizen of the European Union, and currently as a resident of Greece. Now, in the old days, this sort of image wouldn't exist because the United Kingdom was part of the EU. But what has now happened as a result of Brexit is that we require a change in mindset. And the change in mindset requires us to think of the United Kingdom and to treat the United Kingdom as a third country in relation to the European Union, albeit a third country that is still associated with the European Union as a result of the EU-UK, or as I tend to say it, the UK-EU withdrawal agreement and the UK-EU free trade agreement, together with other bilateral agreements, arrangements and understandings. Now, the context. Let me just say a word or two about the context before I set out the main objectives of this presentation and then try to attain them over the next 50 minutes or so. Since Russia re-invaded Ukraine on the 24th of February 2022, the UK government and the UK Parliament have adopted what the former Prime Minister described when he was still Prime Minister in February 22 as draconian measures in response. I just want to emphasize something here. Russia originally invaded Ukraine in 2014. For many countries around the world, including, I regret to say, the Republic of Cyprus and the United Kingdom, it was more or less, for reasons I'm going to sketch out, business as usual. There were a few token measures taken, a few more austere measures taken, but by and large, it was business as usual as regards Russia. And it's only now, since Russia re-invaded on the 24th of February 2022, that the UK government and the EU have started to take quite austere, or as the then Prime Minister Johnson called them, draconian measures in response. And in a sense, without expressing any support for any side in this conflict, the crux of the matter is that we are in a draconian new epoch for lawyers. And even though my focus today is on England, which is one of the 4 countries in the United Kingdom, the draconian measures in England have the innate potential to spill over into the Republic of Cyprus and have implications for lawyers practicing in the Republic. So that's the emphasis, or that's rather part of the context against which today's presentation takes place. And I'll look at some of these measures as we go on. Here's a key point. Again, this is part of my introduction. Here's a key point. This year, the UK has been updating and indeed augmenting its post-Brexit financial sanctions regime. When we, that is to say the United Kingdom, was in the European Union, we were part of the EU sanctions regime. We now have our own separate UK financial sanctions regime. There are similarities in many respects between the UK sanctions regime and the EU sanctions regime, but the key point that everyone needs to grasp is there is now a separate UK sanctions regime which is different to the EU one. So lawyers in the Republic of Cyprus need to, I'm sure they're already doing this, their mindset needs to undergo a shift from the pre-Brexit era to what we are in now, which is the post-Brexit era. Let me just make one other point as I have this particular slide on the screen. You can see there that the UK operates a human rights sanctions regime alongside the anti-Russia financial sanctions regime. There are a mixture of sanctions regimes. Some of them are thematic, some of them are country specific. What you'll notice about this particular image, that's a UK government image, is that in spite of Turkey having one of the worst human rights records in the world, and according to the statistics of the European Court of Human Rights, the worst human rights record among the 46 member states of the Council of Europe, Turkey's not on that list. And that is part of the problem with the financial sanctions regime of the UK at the moment. It is selective and it's driven by political criteria which have knock-on effects as far as lawyers are concerned. Now, why is that important for lawyers in Cyprus? I'll explain in a moment or two in more detail, but the relevance of this is that even though Turkey is not subject to UK financial sanctions, it is becoming a critical actor in the sanctions evasion activities of individuals, or some of the individuals, I should say, some of the individuals who are subject to sanctions, or some of the entities that are subject to sanctions. That's not my view, that's the UK government's view. So even though the UK government, in a sense, has whitewashed Turkey by not placing Turkey under a sanctions regime, Turkey, for political reasons, Turkey is becoming part of the global sanctions evasion activities that all lawyers need to be aware of. At this point, my slides have frozen, but I've unfrozen them. Now, why is that relevant? It's relevant because Turkey is not just the occupying power. Let me just deal with that first. Turkey is, on the one hand, the occupying power in the north of the Republic of Cyprus. We have UN Security Council Resolution 550 of 1984 that implicitly says that, and we have various court judgments, including a judgment of the European Court of Human Rights in the a judgment from 2019 in the Güzelirutlu case, if I pronounced that correctly. The European Court of Human Rights notes that Turkey is regarded by the international community as being an occupation of the northern part of Cyprus. So as far as international law is concerned, Turkey is the occupying power in the north of the Republic of Cyprus. Now that's critical in view of the matters that I'm now going to flag up. If one looks at the, let's deal with this slide. If one looks at the evasions methods that are now being deployed across the world, and here I'm quoting from a red alert, as it was called, published by the National Crime Agency and a number of other public bodies in the United Kingdom earlier this year. Turkey, China, Brazil, India, and certain parts of the former Soviet Union, excluding the Baltic states and Ukraine, are falling under the spotlight of certain persons who seek to transfer assets and funds directly and indirectly to jurisdictions where sanctions are not in place. The United Arab Emirates is also on that list. So the key point here, the key point that I want everyone to grasp is that the UK government, even though they haven't put Turkey under a sanctions regime, acknowledges openly that Turkey is now being exploited, or is suspected of being exploited, for financial sanctions activities. The other point that I want to stress in the context of Turkey is that if one looks at the Financial Action Task Force updated list of high risk and other monitored jurisdictions, one finds Turkey in amongst them. And partly as a result of that, the United Kingdom government has this year introduced a delegated legislation through the UK Parliament that is now part of English law to acknowledge that reality. So if one looks at the list of high-risk third countries as far as English law is concerned, one finds Turkey. One also finds some other neighbours of the Republic of Cyprus, including Syria. But what one also finds, and this is relevant to what I'm going to discuss in a moment or two, are two of the dozen or so British overseas territories which are left. One is the Cayman Islands, and the other one is Gibraltar. Finally, in this introductory context, these are all introductory comments, and you can see what I've done here. I've given you hyperlinks to trace the primary sources that I'm flagging up here. I don't have time to go through all of them, but I'm at least after today's class, you can secure the slides which I've uploaded on the Microsoft Teams page. What we have in the island of Cyprus, as distinct from the Republic of Cyprus, are two remnants of the Crown Colony of Cyprus known as the sovereign base areas, and they, it would appear, are subject to a mixture of laws which are emanating from the UK Parliament in Westminster and laws emanating from the sovereign base areas, unelected I should say, sovereign base areas administration in Episkopi. So bear in mind that when you're dealing with the United Kingdom, you need to have in mind on the one hand, the United Kingdom and the four constituent elements of the United Kingdom, each of which has now its own individual legal system because of the new parliaments that have cropped up in Northern Ireland, Scotland and Wales. And on the other hand, one needs to have regard to the mixture of Westminster-derived and Episkopi-derived laws in the sovereign base areas. And those laws can have knock-on effects as far as both anti-money laundering and financial sanctions are concerned. So I'm now come to the final part of this introduction where I'm just flagging up certain issues and the context against which today's presentation is taking place. The other thing that I want everyone to note, and this is critically important potentially for lawyers in the Republic of Cyprus who have company clients or other entities within their client portfolio that own property or seek to own property in the United Kingdom, not just England and Wales. And this is the Economic Crime Transparency and Enforcement Act 2022, which was rushed through the UK Parliament in the 2 or 3 weeks after the Russian reinvasion of Ukraine on the 24th of February 2022, and it received royal assent on the 15th of March 2022. Now, what this act does, I'll touch on it later on when I go through some of the details, but what I want to flag up in this introduction is the question that Companies House has posed in a message it published on the 9th of December 2022. Do you work with overseas entities that own land or property in the UK? Question mark. Overseas entities in scope, what they mean by that is within the scope of the legislation, need to register on the new register of overseas entities by the 31st of January 2023. Find out more at the link that's given. So if one of the reasons why we decided to organise this event was to flag up this new legislation in the United Kingdom Parliament and to flag up some of its potential implications for lawyers and their clients in the Republic of Cyprus. Now, clearly, I'll just say it now before I move on, lawyers in the Republic of Cyprus are not lawyers in the United Kingdom, but they may, depending on the circumstances, need to advise their clients to seek legal advice from appropriate solicitors in one of the 4 jurisdictions in the United Kingdom in order to comply with this legislation and that looming deadline. Now, in closing this introductory part, let me sketch out the 5 objectives that I'm going to try and address over the next, 40 minutes or so that's left. The first objective is to try to consider why the United Kingdom has attracted so many illicit financial flows from overseas, including the Republic of Cyprus and Russia. And one of the themes of the presentation is that, unfortunately, there is a perception, and to some extent there is a reality, that Cyprus, Russia, and the United Kingdom are used on a relatively routine basis by criminals seeking to launder their illicit monies. So that's what I want to try and explore as one of the purposes of the presentation. A second purpose is to identify, I've already touched on some of these, to identify some of the acts of Parliament, regulations and cases in the draconian anti-money laundering and financial sanctions regime in post-Brexit England. Thirdly, this I'll do towards the end, I want to question some of the features of the regime which are hard to reconcile with the rule of law, professional ethics, or basic tenets of the lawyer-client relationship, such as client confidentiality. And the fourth purpose, which I've already started to do, is to offer practical suggestions aimed at lawyers in the Republic of Cyprus with cases or clients linked to the United Kingdom. Although in saying that, because of the fragmentation of the United Kingdom, most of what I'm going to say is rooted in the law of England or the practices associated with England. And the final objective is to draw your attention to some reading material that is freely available online. So let's move on to the arguments. What are the arguments of this presentation? Let me identify them now, and I'll spend the rest of the webinar going into some details which interlink with both the purposes and the arguments. Right, here they are. The first argument I'm going to advance is that economic crime is antithetical to the rule of law and must be confronted in firm but fair ways. That's my first proposition. My second proposition is that since 2000, that's when the Terrorism Act 2000 received royal assent, in the legislation enacted by the UK Parliament to confront economic crime appears to have collided with some of the core principles underpinning the rule of law and the lawyer-client relationship. The most obvious one there being client confidentiality, which as a principle has been severely eroded as a result of the legislation. The third argument, and this is a very important one, is that due to certain defects and deficiencies in the constitutional, legal and regulatory architecture of the UK for which they are responsible, the UK government and UK Parliament have effectively facilitated economic crime. Now, I'm going to give you some tangible examples which every lawyer in the Republic of Cyprus needs to be aware of so that they don't fall into the trap of suffering harm or having their clients suffer harm as a result of the mistakes which have been made by the UK government and the UK Parliament. The fourth argument is, as I've already indicated, that the UK and the Republic of Cyprus have been caught in a web of crime stemming from Russia and Turkey. And here's my fifth argument. The draconian post-Brexit anti-money laundering and financial sanctions measures adopted this year have effectively shut the stable door after the horse has already bolted. So, practical suggestion before I turn to the details. We have in the United Kingdom these parallel regimes on anti-money laundering and financial sanctions. They constitute the two sides of the same coin, and each one has formidable legal, that includes criminal and non-criminal, equitable and ethical and regulatory implications for lawyers. There's a typo there. That should be a non-criminal, forgive me. I'll just correct that. And I'll upload the updated slides.
We will circulate the slides. Yeah, we will circulate the revised slides later, Klearchos, so don't worry about it.
Thank you. The point that I want everyone to grasp is, and this is the guidance given to solicitors in England and Wales by the Solicitors Regulation Authorities, there is this massive new legislation. So there's one Act of Parliament after another coming out of the UK Parliament that touches on anti-money laundering or financial sanctions. There's even more legislation coming through in the form of delegated legislation, that is to say statutory instruments which provide details built around the outline set out in the Acts of Parliament. But leaving aside all of that complexity, what the Solicitors Regulation Authority does as regulator for solicitors is highlight the significance of two questions, which I would suggest are, among others, two of the key questions that every practicing lawyer needs to consider, not just after a case has begun, but to consider before actually embarking upon the case and taking on a client. The first question is, am I sure all of the parties in any matter are who they say they are? I mean, this is absolutely fundamental question, and so many problems can be nipped in the bud if at the very outset of a case, the solicitor, or I should say the lawyer in the Republic of Cyprus, is sure that all parties are who they say they are. Now note the wording here, they don't say all clients, all parties. That's a broad phrase that the SRA has used, and it encompasses literally all of the parties who were involved in a particular matter. So the lawyers now at the outset of the case, in England and Wales at least, are being invited to check the identities insofar as they can and the veracity of all of the parties involved in a particular case. And the second key question that needs to be asked is, does the client or the client's matter make sense? If it does not, you should continue asking questions and digging into the details until you understand what is happening and why. And that comment which the SRA have placed in relation to the second question, I would suggest can be applied to the first question as well. So leaving aside all of the details and this torrent of legislation, the basic principles remain the same. These are two of the questions that need to be asked at the outset of a new case. and all of the other things I'm sure we'll discuss later in the presentation and the question and answer session need to be covered as well. Risk management, risk limitation, customer due diligence, and so on. Let me now turn to my what's wrong with the United Kingdom and what lawyers in the Republic of Cyprus need to be aware of if they ever encounter a client or a case or any other matter that involves the United Kingdom. The first point to note is there is really, with the exception of a few judgments of the Supreme Court of the United Kingdom and with the exception of some UK-wide acts of Parliament, there is really no such thing as UK law. What we have now are, even though we refer to the law of England and Wales, even that is being split into two. We really do have 4 countries, each of which has their own law and their own legal system. So the first point to note is, if you take on a client from the UK, and they say they're from the UK, work out which particular part of the UK they're from. Are they from England, Wales, Scotland, and Northern Ireland? The second point that I want to make in this context is that even though if you look at those financial action task force list of high-risk jurisdictions or jurisdictions under increased monitoring, the UK is not there. The Cayman Islands and Gibraltar may be there, but the United Kingdom as such is not there. That does not mean that the United Kingdom is risk-free. For the reasons I'm going to sketch out over just the next few minutes, I'm going to highlight why any case involving the United Kingdom should really raise a red flag in the office. That's particularly the case if a company is involved. If it's an individual with a salary from a let's say a public body, and they're buying a property at a relatively low value, and the other party appears to be genuine, that may be a low risk case. But when you're dealing with a company or certain types of company from the United Kingdom, red flags should be raised, not necessarily because there's something wrong with the company, but there's something wrong with the company structure that we have developed in the United Kingdom. Let me explain. I've already made the point. Well, I'll make the point as I put the slide where I have. One thing you've got to bear in mind is, if you're dealing with a company or an individual, where do they fit into this picture? Are they from the United Kingdom or from one of the 4 countries of the United Kingdom? Are they like me, who was born and brought up in the United Kingdom and has a UK passport, but is now residing overseas and may, like me, have dual citizenship? Or is the company or the individual you're dealing with from one of the 12 also remaining British overseas territories, plus the remaining Crown dependencies, that is to say the Isle of Man, Guernsey, and Jersey? Now, the problem we have, this is why I would suggest to you that the United Kingdom is, to all intents and purposes, a high-risk jurisdiction or a problematical jurisdiction, even though it doesn't appear on the Financial Action Task Force lists. Look at this. This is the National Crime Agency website 2 days ago. This is what it says. Money laundering underpins and enables most forms of organised crime, allowing crime groups to further their operations and conceal their assets. Although there are no exact figures, there is a realistic possibility that the scale of money laundering impacting the UK annually is in the hundreds of billions of pounds. Hundreds of billions of pounds. Why is that so? Why, in the perception of the National Crime Agency, is the United Kingdom impacted annually by hundreds of billions of pounds of laundered money? Well, one reason, and there are several, I'm going to just pinpoint them over the next few minutes. One reason is that the United Kingdom, particularly during the Boris Yeltsin years of the 1990s and the early years of the Putin regime during the 2000s, when he was in the good books of the British government, the British state enabled London to become what's called a laundromat for corrupt money. That's the phrase that was used by the UK Parliament Intelligence and Security Select Committee in its report on Russia published in July 2020. They actually finished it before the 2019 general election, and for various reasons we haven't yet fully discovered, there was a delay in publication until after the 2019 general election, and then it was eventually published. What gives that report added credence is the fact that it was the product of a committee chaired by Dominic Grieve, QC MP as he then was, during the former holder of the Office of Attorney General of England and Wales. I'll come to that. I'll come back to that a little bit later on if I've got time. Another point I just want to flag up here: whenever you're dealing with the United Kingdom or a public body in the United Kingdom, or have to make a report to any body in the United Kingdom, you need to check where the body is based and what its scope is. So to give you a very simple example, the National Fraud and Cybersecurity Reporting Centre, which is responsible for action fraud, that's the police unit responsible for confronting fraud as distinct from money laundering. It's called the National Fraud and Cybersecurity Reporting Centre, but the Scottish police force is not involved, and therefore Scotland is excluded from the framework of this national body. And this is just a sign of what's gone wrong in the United Kingdom without anti-crime efforts. We don't really have a proper joined up national crime effort. We do, however, have the National Crime Economic Centre, and we have lots of different bodies that are involved in confronting economic crime, and on that screen you can see some of them. And here is, in a sense, another of the problems that we've got in the United Kingdom. We've got too many bodies fighting crime, and in some respects the left hand doesn't know what the right hand is doing. What is money laundering? Well, I think I'll just give you the English legislative definition. Money laundering is the process by which the proceeds of crime are converted into assets which appear to have a legitimate origin, so that they can be retained permanently or recycled into further criminal enterprises. That is the definition found in the explanatory notes to the Proceeds of Crime Act 2002. In other words, that definition is not in the legislation, but it's in the non-binding explanatory notes to the legislation. That there is a statutory definition as well in section 340 of the Proceeds of Crime Act that I'll let you read in your own time. But the legislation, it criminalises a number of types of activity built around concealing criminal property, becoming concerned in an arrangement relating to criminal property, and acquiring, using and possessing criminal property. The most common type of criminal property being dirty money, money that is the proceeds of crime. And now I come back to the point that I made right at the very beginning, that, and this was a point made by Lord Kerr in a Privy Council case, the very purpose of money laundering is to conceal the provenance of illegally acquired wealth. The problem with the phrase anti-money laundering, as I said right at the beginning, is it focuses on the second part of the picture, the laundering of the dirty money. One needs to have a holistic approach to anti-money laundering, which encompasses anti-crime, because dirty money does not appear from nowhere. It's not plucked from trees. Dirty money emerges from crimes such as modern slavery and human trafficking, contrary to the Modern Slavery Act 2015. Fraud, the proceeds of fraud, contrary to the Fraud Act 2006. The proceeds of drug trafficking, contrary to the Misuse of Drugs Act 1971, and so on. So the point I want everyone to grasp, and this is what I try to teach my students, is do not become trapped within the relatively narrow anti-money laundering framework. You need to have a much broader framework that encompasses anti-crime, so that your mindset is shaped by, on the one hand, the source or the potential source of the potentially criminal money that may be staring at you in the face, and on the other hand, the money laundering scheme that may be designed to clean or appear to clean that dirty money. And there's some of the legislation that I referred to earlier, but there's other legislation. Now, can I just flag up here a couple of things with reference to some maps? The first thing I want to flag up for lawyers in the Republic of Cyprus is the the attractiveness of the United Kingdom as a magnet for criminals. And the second thing that I want to highlight is how the Republic of Cyprus and the island of Cyprus in which the Republic is found is inextricably associated, unfortunately, with criminality in the United Kingdom. And the same applies to Turkey for reasons that I'll make clear. So what you have on the screen here are the main cocaine trafficking routes into Europe. And you can see the United Kingdom, for obvious reasons, is one of the most attractive places for cocaine traffickers. Perhaps of greater relevance for us is that Turkey is one of the world's great transit points for heroin trafficking that originates in Afghanistan or Iran. And you can see this is an image from the US government published in 2021 that highlights the importance of Turkey, and I suspect the Turkish occupied north of the Republic of Cyprus as a bridge from Afghanistan and Iran towards Western Europe and the United Kingdom in particular. Back in 2011, the UK House of Commons Home Affairs Committee ascertained that it's estimated that 75 to 80% of the heroin trafficked from Afghanistan to Western and Central Europe comes via Turkey, and Turkish networks continue to account for 70% of the UK heroin market. But I have to stress here that over the past few years, there have been heroin wars, in inverted commas, going on between heroin trafficking gangs in the United Kingdom. And I'm not sure whether that statistic has gone up or down. But the point is that Turkey, and I suspect the Turkish occupied north of the Republic of Cyprus, are heavily involved in heroin trafficking into the United Kingdom. And that means that the heroin traffickers are looking for ways to launder their dirty money. And yet, and now I come back to my point about mistakes made by the UK government and UK Parliament, and yet, when we were preparing to complete the second stage of Brexit in 2020, the then Secretary of State for International Trade, Liz Truss MP, whatever happened to her, question mark, entered into the UK-Turkey Free Trade Agreement, which was eventually published on the 29th of December 2020. And there's nothing expressly set out in the 356 pages of the UK-Turkey Free Trade Agreement that deals with heroin, drugs, narcotics and trafficking. It's almost a shocking omission, and yet it's a reflection of what's gone wrong in the United Kingdom. We are not addressing problems that need to be addressed, and as a result, we're creating conditions in which economic crime can flourish. We have, in addition to heroin pouring into the United Kingdom and other parts of Europe from Turkey and places further to the east, we've also got, of course, migrant smuggling and human trafficking, which are related but separate concepts. This is a map published in 2016 by the House of Commons Home Affairs Committee that makes my point for me. And those of you who are in the Republic of Cyprus will know that the Republic of Cyprus has been heavily affected by these population flows, as much as, if not more than, in most countries in Europe, at least in percentage terms. So what I want to emphasize here is that as far as English law is concerned, whenever a human trafficking or migrant trafficking or other form of illegal population movement takes place, there's normally or often a criminal gang that's orchestrating the movement or the activity, and that criminal gang will make money and seek to place the dirty money into a money laundering scheme. And that's where lawyers need to be on their guard in case they find themselves wittingly or unwittingly entangled in a scheme designed to cleanse, in inverted commas, dirty money that is, as far as English law is concerned, a crime prohibited by, for example, the Immigration Act 1971 or the Modern Slavery Act 2015. And again, one of the problems we've got in the United Kingdom is that we're not really, maybe for political reasons, we're not keeping up to date with our estimates or with our statistics. Rather shockingly, in 2020, the National Audit Office revealed that the UK Home Office hasn't updated its estimates as to how many people have no right to remain in the United Kingdom. There were 430,000 people without the right to remain in the United Kingdom in 2005. Who knows what the number is today? Now, the point is, if you're dealing with, let us say, a client who is UK based, but is not a UK citizen, you need to ascertain what is whether they have a right to live in the United Kingdom, and if they have a right to live or remain in the United Kingdom, whether they have the relevant paperwork to back that up in the form of the relevant documentation from the UK Home Office, or to be more exact, the border control agency that operates under the Home Office. So the point I'm making, let me just make a very practical point for the lawyers in the audience. An increasing number of UK residents are not UK citizens. That may be because they're EU citizens who've settled in the United Kingdom and they've gone through the registration procedure and have papers to prove that they're legal residents, and those papers are consistent with the EU-UK withdrawal agreement and the related legislation. So you've got, make sure if you're dealing with a UK-based EU citizen that they've got their residency papers in order. And equally, if you're dealing with a non-EU resident of the UK, they've got their Immigration Act papers and Home Office border control papers available. Otherwise, you may find yourselves entangled in a scheme which is illegal. You don't want to find yourself entangled in that scheme. So very, very important practical point there when you're considering taking on a client who's UK based. Now we come to loads of scams going on in the United Kingdom, coronavirus, the pandemic, and this really, in my judgment, really preposterous scheme where we were spending billions of pounds keeping people at home and out of the office for far too long, the furlough scheme. All of these schemes during the pandemic have generated the opportunities for fraudsters and scams to take place. So there is a massive amount of criminality now taking place in the United Kingdom as a result of these types of crime. So be on your guard for UK-sourced crimes associated with the pandemic or some of the other scams, including cryptocurrency scams that are unfortunately proliferating. Now I come to the point that I want really everyone to really note. This is rather quite shocking, but I'll go through it anyway. We had a massive change in legislation in 2006 called the Companies Act 2006, this updated, modernized and refreshed English company law. The problem with that legislation, and it's a grave problem that may have implications for lawyers in the Republic of Cyprus in certain cases, the grave problem with that legislation is it on the one hand placed enormous responsibility into the hands of accountants, but on the other hand, neither that legislation nor any other legislation properly defined what was an accountant in law and enabled accountants to operate in the United Kingdom outside a regulatory framework. In other words, in England, to all intents and purposes, anybody can, in the aftermath of the Companies Act 2006, anybody could call themselves an accountant and offer accountancy services to a company. The company could receive the accounts prepared by an unregulated accountant, submit the accounts to Companies House. Companies House would then publish the accounts, and there would be no regulatory framework in place to protect either the company or anybody coming into contact with that company in the event of the accountant proving to be corrupt or rotten for any other reason. Now, that isn't to criticise the many regulated and professional accountants that we have in the United Kingdom, including those who are regulated by the ICAEW and the ACCA. But we have I have to say, vast number of accountants in the United Kingdom who are operating outside the regulatory framework. And you can read this early day motion that was put forward in the House of Commons on the 3rd of July 2008 that drew attention to this. But only 83 out of 646 MPs signed this motion. So nothing has really happened. And I'm not going to go through the rest of these slides in any great detail, but I just want you to be aware. That when you're dealing with I can't speak about Scotland, Wales or Northern Ireland, but as far as England is concerned, if you're dealing with somebody who calls himself or herself an accountant, that does not mean that that person is regulated by a professional body. That is a shortcoming that, for example, the Association of Accounting Technicians has repeatedly made in evidence to the UK House of Commons Treasury Committee. So on the one hand, whereas doctors, nurses, solicitors and architects are required by law to be members of a relevant professional body, to have practicing certificates, to undergo CPD training, have professional indemnity insurance and so on, or be covered by the equivalent of those things in the public sector through the National Health Service, there's no equivalent obligation on those persons who call themselves accountants. Now, that's unfair for the regulated accountants, but it's also dangerous for anybody who has an unregulated accountant acting for them. And it's also dangerous for anybody, including lawyers in Cyprus, who have any dealings with any company that is relying on the services of an unregulated accountant. So let me just make a few points. I'm conscious that the time's running by. Lawyers need to adopt a holistic approach. It needs to go beyond know your client. You need to know your own firm. It could be that somebody in your own, hopefully this isn't going to happen, but we have too many cases of this in England in recent years. And so I'm going to make the point. You've got to know your own firm. There could be a rogue lawyer or a rogue member of staff in the firm that is leaking information improperly, that is engaged in a criminal scheme for one reason or another. And that needs to be prevented if possible. And if it's spotted, it needs to be rooted out in an appropriate way. So know your client is a good rule of thumb. But my point here is go beyond that. Know your firm, know your place of work, know your client, know the source of funds that are supplying the money to purchase a property, for example. Know who the beneficial owner is. I mean, this is easier said than done, but that's what needs to happen in the modern anti-money laundering climate. Engage in ongoing monitoring and other due diligence checks. But here we come to the crux. If you're dealing with, for example, an English company, you really need to dig away to find out about that company. And that is easier said than done if the company has instructed or has used unregulated accountants. That also means you need to undertake the professional checks if you're dealing with an English or UK based accountant. It could be that they're regulated and they've done an excellent job and the accounts they've produced are first class. That's great. But equally, in certain cases, you might find yourself dealing with an unregulated accountant who's produced a terrible set of accounts, or accounts that have been designed to conceal a criminal scheme, even worse. And I've given you here some details that enable you to go into to obtain further details on how you can go about conducting some of the checks that may need to be done when you're dealing with a UK, an English or UK based accountant or other professional person. Let me now flag up some of the real structural defects in Companies House that have the innate potential to create financial crime and therefore dirty money for the purposes of anti-money laundering. The first point is that this is not my wording. This is taken from the disclaimer at the top of the relevant page of the Companies House website. Companies House is the public body that's responsible for maintaining the register of companies in the United Kingdom. I'm not sure about Northern Ireland, so I'll just stick to England. Companies House is responsible for the register of companies in England, if not other parts of the United Kingdom. The disclaimer says, Companies House does not verify the accuracy of the information held or filed to it. So that's all Companies House has been doing for years. They've been receiving information, publishing it on its website, which is free, easy to use, or relatively easy to use, but there's no verification undertaken by Companies House. By and large, they don't even have the statutory power or capability to verify the accuracy of the information. I mean, this is an astonishing defect that has been exposed this year, and belatedly the UK government's taking measures in the light of the events in Ukraine. But it's astonishing, firstly, that Companies House does not verify the information it receives, and secondly, that it has no statutory power to verify the accuracy of the information it receives. I mean, these are fundamental defects in the UK anti-crime regime, which has the innate potential to cause problems for lawyers in the Republic of Cyprus if they rely on the Companies House documentation at face value. It's good that it's there, but you need to go further if you're dealing with any company. The fact that somebody is named as a director does not necessarily mean that that person is a director. The problem we have here is that Companies House does not verify the identification of the persons who are named as directors on the companies that are registered at Companies House. And another shocking omission. And to make matters even worse, the Companies House has only 1,000 members of staff in its entirety, and yet they're responsible for 12 million individuals on their register. That was a polite complaint made by the head of the legal department at Companies House in evidence to the House of Commons on the 8th of November 2022. And as I've already mentioned, accountants, this is not my wording, this is Companies House wording. Companies do not have to use a professional accountant to prepare accounts. However, directors must be aware of their legal responsibilities. There are exceptions to that. In certain circumstances, accounts have to be audited and the auditors have to be members of a professional body. So you can read the details on that in your own time. Can I just pause there? Stephanie, how many more minutes do I have? You're there.
I think you still have 5 minutes if you would like to, at least 5 minutes.
Thank you. Okay, what I'll do in the 5 minutes left is just flag up the legislation that has been enacted this year and highlight some of the main provisions that need to be borne in mind. So the first thing to note here is that the UK government has belatedly woken up to the huge defects and deficiencies in Companies House. And when he was Secretary of State for Business, Energy and Industrial Strategy, that is to say before his 45 days as Chancellor of the Exchequer under Liz Truss, Kwasi Kwarteng, to his credit, came to the House of Commons on the 28th of February 2022 and admitted in a polite and an indirect way that things have gone very, very wrong at Companies House, and therefore moves are belatedly afoot to correct things. The problem is we have a massive archive of accounts and other documentation relating to companies registered at Companies House, and you cannot place reliance on that mass documentation on its own. You need, in my judgment, to go 1 or 2 or 3 steps further. And you can see here, I'm not going to say anything more other than to flag this up. We have an economic crime and corporate transparency bill going through the UK Parliament to correct some of the mistakes and omissions of the past. So that's a bill that's not yet an act of Parliament that will hopefully reduce some of the problems that exist with Companies House. And there's more details for you to read in your own time. Now, another thing that's gone wrong is that we have, well, I've already said that, we've enabled too much dirty foreign money, not just dirty Russian money, but too much dirty foreign money to enter into the United Kingdom. And unfortunately, the authorities in the United Kingdom, this is, I'm quoting here from the Russia report of the Intelligence and Security Committee of the UK Parliament, for many, many years, the UK welcomed Russian money and few questions, if any, were asked about the provenance of this considerable wealth. So what's the practical relevance of this for lawyers in the Republic of Cyprus? The practical consequence is that you could end up with a client, an individual or a company or other entity that is selling property in the United Kingdom and seeking to reinvest the proceeds of sale in a property in the Republic of Cyprus. The question then arises, how far do you need to go to ascertain the cleanliness of the property that is being sold in England and the cleanliness of the proceeds of sale that are coming from England? What the Russia report teaches us is that many, many properties were purchased in London and other parts of England with the authorities not doing their job properly. And therefore, those properties may still exist and be registered in the names of individuals and companies. And now that the heat is being turned on Russians who are subject to sanctions, those properties may be in the process of being sold and with the proceeds reinvested in places such as the Republic of Cyprus. Although Turkey is probably going to be a more attractive destination for these sorts of people. So just be on your guard that the United Kingdom and England in particular have allowed themselves to become saturated with dirty money from overseas, including places such as Russia. And I've given you here some more details from the report and the response of the UK government. A couple of other things before I close. This is an official Ukrainian state graph that shows the sources of foreign direct investment into Ukraine over the past few years, from 2012 until 2016. And you can see by a long way that Cyprus, one of the geographically smallest countries among the 200 or so member states of the UN, comes top of the list, with the United Kingdom in 5th place. And if you look at there are no results from the State Department for 2022, but if you look at the 2021 investment climate statements of the US State Department for Russia, the foreign direct investment sources, Cyprus was the biggest source of foreign direct investment into Russia, with Bermuda, a British overseas territory, in 2nd place, and the United Kingdom in 4th place behind the Netherlands. What's the point that I'm making here? The point that I'm making here is that the United Kingdom, a number of the British overseas territories, including Bermuda and the Republic of Cyprus, have been involved in global flow of money coming out of Russia. Whether that money is legitimate or not is another matter. But the point is, lawyers in the Republic of Cyprus need to be aware of images such as the one that I've shown you, that show that the Republic of Cyprus, British overseas territories such as Bermuda, the United Kingdom, and Russia, they are all part of the same global financial picture. Illicit in some cases, legal in others. And we're all aware, or we should be aware, of the Manafort case and some of the other cases which show the way in which the United Kingdom, the United States and Cyprus can be involved in illicit global financial flows. So to finish, this is just an overview of our anti-money laundering framework in the United Kingdom. Because of our membership of the European Union until 2020, much of what is in that legislation will already be familiar to lawyers in the Republic of Cyprus. I mean, most of the crimes, most of the provisions that are criminal, in the legislation, including, for example, the tipping off provisions, are taken from the relevant EU directives over the years. So a lot of what is in English law will be familiar to lawyers in the Republic of Cyprus. Where things started to change, however, was when the preparations for Brexit began. So we've had the Criminal Finances Act 2017, the Sanctions and Money Laundering Act 2018, and the new Economic Crime Transparency and Enforcement Act 2022 that are specifically dealing with a post-Brexit environment. And what I've done is I've given you some links a bit later on for you to read about those acts of parliament in more detail. Finally, I think this is probably the place to close. This is all great in the sense that, okay, the UK Parliament has belatedly taken action to clamp down on dirty money, in spite of the fact that both the UK government and the UK Parliament are, in my view, co-responsible for enabling financial crime to take place through their actions and their omissions, including the actions and omissions that I flagged up in today's presentation. But what they've also done through this anti-money laundering regime is create problems for lawyers, and they've altered the relationship between the lawyer and the client, and between the citizen and the state. I'm just going to read this one slide and then I'll wrap up, Stephanie. This is can you imagine a judge saying this today? This was Lord Taylor of Gosforth, the then Lord Chief Justice of England and Wales, sitting in the Appellate Committee of the House of Lords in a case decided in 1995. The principle which runs through all these cases which he analysed, and the many other cases which were cited, is that a man must be able to consult his lawyer in confidence, since otherwise he might hold back the truth. The client must be sure that what he tells his lawyer in confidence will never be revealed without his consent. Legal professional privilege is thus much more than an ordinary rule of evidence, limited in its application to the facts of a particular case. It's a fundamental condition on which the administration of justice as a whole rests. So what anti-money laundering law has done is, on the one hand, it's supposedly helped to clamp down on economic crime, but on the other hand, through the provisions about making suspicious activity reports, it's really undermined the lawyer-client relationship. Although legal professional privilege, I have to say, is a little bit stronger than client confidentiality. Even though the two are interlinked, client confidentiality has been subject to a quite serious process of erosion. I mean, I don't have time to go through some of the other principles here, but you can read them in your own time. That there's the statutory framework in the Proceeds of Crime Act, which more or less mirrors what's in Cypriot law. I'll just say this: a particularly dangerous provision in the Proceeds of Crime Act 2002 is section 328, under which a person commits an offence if he enters into or becomes concerned in an arrangement which he knows or suspects facilitates, by whatever means, the acquisition, retention, use or control of criminal property by or on behalf of another person. But a person does not commit such an offence if he makes an authorised disclosure, and so on and so forth. The point that I want to stress here is that the wording of this and other measures is so broad that it potentially catches a lawyer in the Republic of Cyprus. So there needs to be extra care taken when dealing with a case with an English or UK dimension. I've put on the slides some introductions to the various acts of parliament that I've mentioned. You can read this in your own time. Please, if you have clients from the UK or you have clients with property in the UK, read about the Register of Overseas Entities that the Companies House has created, and I've given you plenty of materials to read from the House of Commons Library, Companies House, and elsewhere, including the UK government. There are some other publications for you to read from the excellent, I must stress, House of Commons Library that publishes briefing papers aimed at the general public. And there are the sanctions lists that you need to be aware of in the UK, the US, the EU, and the EU. So that, ladies and gentlemen, is a whistle-stop tour of English anti-crime and anti-money laundering and financial sanctions law. And hopefully I've addressed the question I posed at the outset. how does that regime affect lawyers in the Republic of Cyprus?
Thank you so much, Klearchos. I think this was extremely helpful, and your slides are always so comprehensive and detailed. There was a comment in the chat, Klearchos, that participants would like to get the slides. So what we will do is that Klearchos will give it one more read post-webinar, and the updated version of the slides will be actually uploaded onto the MS Teams, to which you will continue having access after the course, which, by the way, means that you can also view again the recordings if there is something that you would like to listen to or re-hear. Now, we have a few minutes for a Q&A session with Klearchos. So is there something that participants to this webinar, and we have quite a few people here, would like to ask Klearchos perhaps to clarify or to expand, although I think that it was quite extensive. So the floor is yours. You may type in the chat, or you may take the floor by raising your hand, if anyone would like to. I don't see anything for the moment, Claire. I have a question in the meantime. I was very surprised. I didn't know about regarding the accounting profession, which I find very worrying and not necessarily in line with EU legislation. Of course, we know that post-Brexit, this is less of an issue, but still, professionally speaking, whether you are, in the post-Brexit world or not, should not really matter, because money flows the same way prior, post-Brexit. My only concern, Claire, is in view of the ongoing reform of the legal profession in the UK, have you actually seen anything around the same type of developments for lawyers in the UK?
Yes, well, this is the complaint that has been quite justifiably made on behalf of properly qualified and regulated accountants, that there is a double standard here. To be a solicitor in England and Wales and to call oneself a practicing solicitor, one needs to have a practicing certificate. I don't have a practicing certificate. That's why I describe myself as a non-practicing solicitor in certain cases. But I don't have a practicing certificate, but I'm qualified. I'm on the roll of solicitors. Anyone can find my name on the roll of solicitors. I'm regulated in that limited sense as a non practicing solicitor. A practicing solicitor is under even more onerous duties, because not only are they regulated, but they need to have a current practicing certificate. They need to be under a professional indemnity insurance cover. They need to undergo the annual continuing professional, I think they call it now, continuing competence obligations imposed on them by the Solicitors Regulation Authority. They are subject to potential spot checks in the office by the Solicitors Regulation Authority. They're officers of the court under Section 50 of the Solicitors Act 1974, and therefore they are subject to the protection that's afforded to the public by the relationship that the solicitor has with the court. And there is this massive body of protection that is given to the public through the name solicitor. Protection is given to the public through the phrase chartered accountant or chartered certified accountant, because to be a chartered accountant, as I understand it, you need to be regulated by the ICAEW, that's the professional body that regulates chartered accountants in England and Wales, or by, if you're a chartered certified accountant, by the ACCA, or if you're another type of accountant, you need to be regulated by one of the other regulated bodies. But that is if you're a chartered accountant, or I'll stick to those two. If you're a chartered accountant or chartered certified accountant. The problem is that I was shocked to discover this when I originally discovered it. Anybody can call themselves an accountant and offer accountancy services, as long as they don't mislead the public. they still, and I didn't have time to go through this, so maybe I'll mention it now. They may still, in fact, they ought to, as an unregulated accountant, go on the HM Revenue and Customs register of businesses that are subject to HM Revenue and Customs supervision for money laundering purposes. So there is a sort of a fallback. There is a fallback measure of protection given to the public through that form of supervision. It's not regulation, it's called supervision. That also applies to estate agents who are not regulated by, for example, the RICS, that's the Chartered Surveyors Professional Body. So there are certain types of businesses, such as accountants and estate agents, that may not be regulated by a recognised regulator, but they need to be supervised by HM Revenue and Customs for anti-money laundering purposes. And you can find that register free on the gov.uk website. I put that register of supervised businesses on one of the slides that I've given you. But I go back now to the other part of your answer, that solicitors have been subject to regulatory reforms. So you still have to be qualified and have a practicing certificate to call yourself a practicing certificate, to call yourself a practicing solicitor. But we have new entities cropping up called alternative business structures that are authorised under the Legal Services Act 2007. The practical implication of this is that the old style firm of solicitors that was in the form of a partnership under the Partnership Act 1890 still exists, but it's being gradually replaced by alternative business structures and by limited liability companies under, I think, legislation from the 1990s. So that the framework in which legal services is being provided to the public has changed over the last few years. The logic behind that change is to deregulate the regulated sphere occupied by solicitors and open the market and bring prices down and help consumers. That was the logic back in the 2000s. But what it means for lawyers in the Republic of Cyprus is whenever they're dealing with somebody who calls themselves something, that doesn't necessarily mean that they are who they claim to be. So if, for practical purposes, if somebody claims to be a solicitor, it's advisable, in fact, it's essential to check that they're on the SRA register. There's a parallel law society, the SRA being the regulatory body, the law society being the representative body. They both maintain registers. There's a snag there. I remember this when I was in practice. I had one case where we needed to dig even further than that. Just because a solicitor is named as a solicitor on the register held by the SRA or the law society doesn't mean that they're still there. It could be that they were struck off last week and the SRA haven't had time to update their records. So sometimes a telephone call to the SRA may be advisable in addition to checking on the register. But at the very least, what the UK authorities have done through the Law Society and the SRA is create a register for you to check that person who claims to be a solicitor is a solicitor. The same applies to the ICAEW for chartered surveyors and ACCA for chartered certified, sorry, did I say surveyors? Chartered accountants, and ACCA for chartered certified accountants. Their registers are freely available online. The problem with an unregulated person is there is no register to check on, except the supervised business register of HM Revenue and Customs. So what I'm driving at here is these know your client checks could be applicable in the context I've given you if your client is a solicitor or an accountant who's in London, say. But if you're dealing with a client who's in Cyprus, but they're having a case that has an English dimension, you need to do what I would call know your professional checks on a transnational basis. I hope that answers your question, Stephanie.
It does, Klearchos. Thank you very much. I think this is very, sound advice. In any case, you know your professionals, and this is valid for Republic of Cyprus professionals the way it is valid for any professional, really. So that's, I think, very helpful. Thank you very much. I think we will have at some point to have.
Stephanie, just quick thing I forgot to mention, the Financial Conduct Authority register as well. Many people who are operating in financial services are regulated by the Financial Conduct Authority, and that register is freely available online. I should have flagged that up during the presentation. I've done it now.
Thank you. And this is, of course, something where I think we would probably provide an update webinar or something, because especially the latter point that you just made, this is of high relevance for Cyprus, and the market is increasing. The size of the market is increasing. The size of the professions is increasing. So this is something that we will need to look at, definitely. That is very good. Thank you so much. I also encourage people to have a look at the latest Moneyval report on Cyprus. I haven't had a chance to mention it, neither did you. I'm not sure whether Christian is planning on mentioning it. Let's see. So thank you, Klearchos. I hope you stay with us until the end of the webinar. It's now time to move to the second session of the webinar. We welcome our colleague, Christian Pelaghias. Christian is, of course, a well-known lawyer in Larnaca, but not only. Christian is also an associate lecturer at the School of Law, UCLan Cyprus, so we have the pleasure of having him as a colleague. Christian actually teaches AML law on the LLM together with Klearchos. So the two of you are actually involved in a couple of very specialized LLM modules delivered across the LLM financial and commercial law and international business law, as well as the LLM law. In terms of a module that we call the Law of International Financial Transaction. So we are privileged tonight that you are giving us, an expanded version of some of the items and the issues that you're actually speaking about at the LLM level, and on which the LLM students are actually studying and working, including in terms of essay writing, assignments and seminar preparations, but also potentially exams. Now, Christian, the floor is yours, and you are going to talk to us about AML compliance, with a particular focus on something which is very important for the Republic of Cyprus in the past year or so, which is beneficial ownership, transparency, and fundamental rights in the Republic of Cyprus and the EU. And myself, being a professor of European law, I very much look forward to listening to what you have to say. So, Christian, you've got an hour maximum, and we thank you very much. Do you want to share your slides with us?
So thank you so much for your introduction, Stephanie. You're putting a lot of pressure on me. I hope that I can deliver on your kind words. Just as Stephanie also mentioned, I'm an associate lecturer in AML compliance with the university, and I have been working in AML compliance for a good part of over 10 years now, or even a little bit more, in various sort of stages, and I've seen the implementation of more and more stricter sort of compliance rules being implemented in Cyprus, but also participated in a lot of workshops in Europe and internationally on this subject. My topic is in contrast to Klearchos, which went very sort of deep into sort of the complexities of money laundering in the UK. I'm intending to take perhaps a little bit of a step back and concentrate on an issue that I believe is one of the most crucial questions that we as lawyers have to ask ourselves when dealing with these types of rules and regulations. Because it is one thing to say that, yes, it is important that we have rigorous AML legislation and that we must follow it, and that we have to contribute to the benefit of the international financial scene and so on, and safeguard Cyprus's role as a financial center and whatnot. But at the same time, we have to ask ourselves, how far are these rules also going? And is there at some point where we actually have to say that, well, we acknowledge the fact that the purpose of these rules have an objective to fulfill, but at the same time, there are other things that we also need to take into consideration and safeguard, especially when it comes to questions of individual privacy and the individual rights to certain freedoms that are guaranteed by law. And because this is what we have to do as being part of a democratic society. And so my question is sort of, it's the transparency versus privacy, which is an ongoing debate. It is a debate that has been continuously growing stronger over the last few years, especially with the implementation of the ultimate beneficial owner registries across Europe. And some say that this is something very positive. Others argue that this is something very negative. Some strike a middle ground, and they seem to say that, well, it has its benefits, it has its negatives, but we have to try to sort of find a middle stand here where we can balance the two concepts against each other. But just before we jump into sort of the various arguments that have been presented, let's just take a sort of a look at this is just a sort of a timeline of how long this debate has actually been around. I mean, in Cyprus, we have only for the last sort of perhaps 10 years been focusing a lot on money laundering and terrorist financing issues and compliance. Prior to that, it was barely even mentioned. Nobody gave any attention to it. Nobody didn't really care. And that's despite the fact that the first AML legislation was enacted in Cyprus in 1997. But even that did not strike any particular sort of concern with anybody, or that was something that we really needed to pay attention to. But in fact, this is something that has been the development of AML and AML compliance is something that has been developing over the last 100 years. If we go as far back as sort of the establishment of the Commission after the Prohibition era ended in the 1920s in the United States with organized crime, the war on drugs in 1980s, the OECD campaign against money laundering and tax evasion that gave birth to the Financial Action Task Force and the money laundering regulations there, the 40 guidelines as they are known, and the first AML directive that actually was enacted in 1991. It was extremely thin, but it was still from 91. We now have in 2001, 9/11 with the war on terrorism, and we can see that there was a trend shift there from focus on organized crime for money purposes into sort of trying to stem financing of terrorist activities. We have the Financial Action Task Force terrorist financing guidelines. 9 guidelines that gave birth to the concept of 40+9 guidelines from the Financial Action Task Force. We also have the second AML directive from the European Union coming in 2001. At the same time, the third AML directive in 2005. The global economic meltdown that sort of came about in 2007 also began to expose a lot of the mischiefs and corruption that had been sort of underlying the financial market, especially in places like London and New York, for many, many years, which prompted to the declaration from the Obama administration in 2009, the war on tax havens, which in turn gave the birth to what is known as FATCA in 2010. What's interesting with that is that while FATCA obliges states to sign what's known as intergovernmental agreements together with the United States and provide information to the IRS, the reciprocal end of that is very limited. So the United States will give out very little information, but it will take a lot of information. And here comes the issue about sharing information, because all of a sudden we have the question that there's a lot of data on individuals that perhaps should not be shared, but they are still being disclosed to the governments, and the governments are in turn sharing this information together with other governments. And this is where the discussion really came about how to safeguard individual data. We also have the G8's commitment on transparency in the corporate world in 2013, which sort of set the seed for what we today have as the ultimate beneficial ownership registries. Then we have the OECD Common Reporting Standard in 2014, fourth AML Directive in 2015 that introduces the concept of an UBO registry. We then have the Panama Papers that sort of shocked the financial service world. Again, started posing a lot of questions. Is this right? How can it be that this information is not publicly available? You had a lot of prominent politicians and celebrities who were hiding their money, who were not paying tax, and so on, which brings us to the fifth AML directive that amended a lot of the issues, the problems that the fourth AML directive had in 2018, followed by the sixth AML directive in 2020. So we see that this is a long-going process that has, to a certain extent, pushed the financial service industry into a corner and pushed lawyers and accountants and various level of sort of service provider, almost forcing them into acting without being allowed to criticize some of these rules because it is considered to be counterproductive to the fight against money laundering and terrorist financing, which today has become synonyms of almost requesting any type of information, whether it's relevant or not, simply that you can justify it by AML, know your client's due diligence procedures. I know that I may sound a bit sort of pessimistic and negative, but I want to sort of use this opportunity to raise some of these questions that are sort of absent in the public debate these days of where these rules are going. So if we look at sort of the issue about UBO disclosure, and we go back to 2013 and G8 leaders' commitment to an action plan addressing the misuse of company arrangements and so on. Now, that following with the fourth AML directive to introduce the UBO registries, and that was later amended by the fifth AML directive, the only justification for these beneficial owner disclosures, as they were referred to, was that it was in support of the law enforcement effort in making it easier for governments and other authorities to investigate and prevent illicit financial activity. It would enable better investigation and deterrence of criminal activity, and it would create and encourage greater transparency, fairness, and confidence both between businesses in the private sector and more generally. This makes a lot of sense, considering that this is in the backdrop of all the financial mischiefs that were conducted, and the problems that the global financial market was sort of facing, as well as in the backdrop of a lot of revelations of criminal activity that was conducted, and straightforward laundering of funds and so on. So it makes sense that these arguments would be made in order to justify that the information and details of individuals that own companies and therefore have the financial benefit of ownership and of companies, that this should be made available for anybody that wants to know. Now, for the benefit of who, though, was the question. And the common sort of argument is that you can divide this benefit into three sections. The first is for government use, which includes law enforcement and relevant competent authorities, various jurisdictions and so on. The private sector use, which includes obliged entities like service providers, non-obliged entities, sort of as, for example, if I'm conducting a business and I want to know who's on the other end, then I should have an interest of being able to investigate and find out and do proper due diligence on that counterparty. And the third is the civil society, which sort of gave the birth of the argument that there was an underlying public interest for journalists and various researchers, sort of the general public, in order to balance and provide an additional checks and balances with regard to these types of information. It was also argued that if journalists and NGOs were given the ability to sort of do this research, they would in effect be assisting the government in unfolding illicit transaction and shady corporate structures and sort of help in the hunt of money launderers and criminals. So if we look at how these rules sort of have been, some of you obviously will already know this, but this is Article 31 and 3 of the, what was the 4th AML directive, which then was amended to the 5th, that member states shall ensure that corporate and other legal entities incorporated within the territory are required to obtain and hold adequate, accurate, and current information on their beneficial ownership. But more interesting, we have Article 35 that states that member states shall ensure that the information on the beneficial ownership is accessible in all cases to competent authorities like financial investigation units without any restrictions, be obliged entities within the framework of customer due diligence, and any member of the general public. This mirrors what I just mentioned, that these were the three institutions, let's say, that should have be privy to this type, the beneficial ownership information. It's important to notice that in point C, there used to be a requirement to show a legitimate interest. That was removed in the 5th AML directive for the reason that when pushed, neither the Commission or any of the sort of working groups were able to find a satisfactory definition of what a legitimate interest actually means. So what they did instead of saying that any member of the general public who could show a legitimate interest would be privy to this information, they simply took that away and gave it to any member of the general public. So, and we also see what type of information that was given access to, namely the name, the month, and the year of birth, and the country of residence, And today, if you get an extract from the UBO registry, which you can still do even though it's been closed down, you will see that this is the information that you can get. Now, they do, however, leave the window open so that member states, if they deem it necessary, can individually request for additional information to be submitted as well. We also have Article 35A and 9. The 5A, which states may choose to make information held in the national registers that they can make it accessible online and for a payment of a fee in order for this information to be accessible. This has been different depending on which states you have. Certain member states have had quite high restrictions on getting access with registration and paying anywhere from 50 euros to 200 euros to get it. Others has left it completely open, and others, so like Cyprus, has charged 350. Now, obviously, it wouldn't be justifiable and balanced to demand that this type of information would have to be handed over without any particular sort of protection for the individual. And that's why in 39, there are, in exceptional circumstances, exemption can be granted, provided that the beneficial owner can show that there is a disproportionate risk of fraud, kidnapping, blackmail, extortion, harassment, and so on and so forth. We can perhaps later discuss on how realistic these requirements actually are, but that's anyway what what was granted. Now, on the other hand, we have the issue of the right to privacy. So the arguments here are simple that, well, because beneficial ownership data includes data about people and it concerns publishing of information that could interfere and threaten individuals' right to privacy and the protection of their personal data, therefore, we need to act with caution. And the two main questions here were, and continues to be throughout this debate, is do beneficial owner registry contravene or conflict with data protection and privacy laws? And secondly, is the making of beneficial ownership information public necessary in order to achieve the goals? The goals, as we remember, were to stem the spread of illicit activity and prevent the susception of the European economy to money laundering and other illicit acts. So obviously that protecting privacy is not necessary without secrecy or anonymity, but rather about giving individuals control over their lives and own decisions. As a result, policy initiatives that have potential impacts on private rights demand careful legal consideration. And this, I believe, is a valid point. Now, it's not necessary to another argument that was saying was that it's not necessary to publish ownership information in the public register to meet the global to meet the goal of detecting or deterring illegal activity, improving the business environment overall. Meaning that since this information is already being given to the authorities, who should be the competent, organs to deal with these types of issues, there is no need to provide this information on a more general public base. So now, any student of international law knows that, or human rights law, sorry, knows that privacy is not an absolute right. And therefore, in order to, if you're going to have a policy that interferes with fundamental human rights, it must be justified. In order to be justified, it needs to be in accordance with the law, necessary to achieve the legitimate aim, and proportionate to that particular aim. So in the case of data protection laws, they give the effect of the government's obligation to respect the privacy and rights of individuals, ensuring that the proper restriction on how personal data is used and secured. And there is a sort of a joint balance here between the right to privacy, and the right to data protection. And if we look at the Charter of Fundamental Rights of the European Union, in Article 7, we have the respect for private and family life. Everyone has the right to respect for his and her private or family life, home, and communication. It's pretty straightforward. Article 8, protection of personal data. Anyone has the right to protection of personal data concerning him or her. Such data must be processed fairly for specified purposes and on the basis of the consent of the person concerned or some other legitimate basis laid down by law. Everyone has the right of access to data which has been collected concerning him or her and the right to have it rectified. Compliance with these rules shall be subject to control by an independent authority. So, which means that when we're talking about disclosure of ultimate beneficial ownership information, we are directly imposed with the question of whether or not the disclosure is in violation or can be intrusive on any of these rights. And while we're discussing Article 7 and Article 8, you also have to take into account the European Convention on Human Rights with the right to respect private and family life. So it's a pretty heavy counter-argument on the side of sort of the pro-privacy advocates that these are pretty stringent rules that needs to be taken into account. So we have this within the transparency versus privacy debate, we detect that there are two different aspects of it. We first have the question of public disclosure of UBO information versus the making of the UBO information public. So on the one hand, we have to disclose this UBO information to the public sector. That means to the government authorities and to financial institutions and so on, vis-a-vis to give this information a complete carte blanche openness to anybody without even having to demonstrate a legitimate interest or not. And let me just, okay. So we come therefore to the recent court case from the European Court of Justice. I'm not going to, I'm going to try to avoid going into too much detail of what was actually said in this particular case. It's not that it's not interesting, it's extremely interesting, and the court makes a lot of good arguments, and the methodology used by the court is very helpful in these issues. But the purpose here is to see rather how the court dealt with some of these issues that I've already mentioned, rather than to actually do a sort of an in-depth analysis on every single argument that the court was adjudicating. But if you look sort of at the first case, which is known as WM, this was an individual who was he owned a real estate company in Luxembourg, and that he requested from the Luxembourg Business Registry under Article 15 of the Luxembourg law, which is the equivalent of Article 30 in the AML directive, that the access to his information concerning his UBO, as UBO, would be restricted. And the grounds that he gave for this was that because he traveled a lot and he was traveling to various destinations to where this particular information about him could put him in disproportionate risk of fraud and kidnapping and whatnot, that it should be restricted. But the Luxembourg Business Registry denied that request and basically said that, well, it can't be you cannot prove that this is the case, and therefore you have not been able to establish that you are in any form or way in this proportionate risk of this happening to you. At the same time, almost, there's the case of Sovin, where that particular company also submitted an application to the Luxembourg registry requesting that the access to the ultimate beneficial information contained in the registry be restricted, again under the same exemption in Article 15 of the Luxembourg law, which was also rejected by the registry. As follow-up, Sovereign, same as WN, filed with the Luxembourg District Court and requested that the decision would be overturned. The main arguments for the appeal made by Sovereign was that the granting of public access to identify the personal data of its UBO would infringe on the right to respect for private and family life and the right to protection of personal data. Remember, in WN case, he wanted the court to grant him the right to be excluded. Here, the question was rather, is this in conflict with the right of privacy and the protection of personal data? So there were several questions raised by the court. I will focus, rather than but the court focused only on question 1 in the Sovereign case, namely related to the validity of making the beneficial owner information accessible to the general public, and whether or not that could be considered as legitimate. And the actual question posed was,
So I can't see the presentation anymore.
It got lost.
Okay, so unshare your screen maybe. And then find it on your computer. Ah, wait, it's coming again. Great, we can see it again, Christian.
Yeah. So the question that was posed in the Sovereign case was, is Article 1.5c of Directive of the 5th AML Directive, this is the provision that changed from Article 35c from being with the requirement of having a legitimate interest to just being publicly available. If that, so far, requires member states to make information of beneficial owner accessible to the general public in all cases with no requirement for legitimate interest to be shown, is this a valid provision? In the light of the right of respect to private family as guaranteed under Article 7, and as well interpret in accordance with Article 8 of the European Convention of Human Rights, and weighing that against the recitals in the objective stated in recitals 30 and 31 of the 5th AML Directive, namely for the effort of combating money laundering and terrorist financing, and B, in the light of the right to protection of personal data guaranteed by Article 8 of the Charter, insofar as it is intended inter alia to guarantee the personal data are processed lawfully, fairly, and with a transparent manner in relation to the data subject, that the purposes for which such data are connected and limited, and that the data are minimized. So, as I said, I'm not going to go too much into the actual arguments of the court, but the judgment that came out, and we all know what the judgment is, so there is no spoilers here. Namely that Article 1.15c of the 5th AML Directive that amended the 4th AML Directive is invalid so far as it amended point C of the first paragraph of Article 35 of the 4th AML Directive. So essentially what the court said was, no, you cannot have such an open registry based on the fact that there is simply nothing that guarantees that these rights will not be intruded on. And the way that the court came to this conclusion was quite interesting, and it essentially followed what we mentioned before. It's asked the question whether or not the intrusion were legal, whether it was necessary in order to achieve the goals, and whether or not they were proportionate. So the first step that the court took was whether this was an interference with the fundamental right guaranteed in Articles 7 and 8 of the Charter, resulting from the general public access of information and beneficial ownership. It came to the conclusion that it was an interference of Articles 7 and 8. It continued also to say, ask the question whether this was whether the seriousness of that interference was so high that it could not be disregarded from, and it came to the conclusion that it was a very serious interference in the fundamental rights enshrined in Articles 7 and 8. It then posed the question whether or not the justification for the interference resulting from the general public access to information of beneficial ownership. Now, as we mentioned before, and the court also made a point of this, that fundamental rights are not in Article 7 and 8 are not absolute, and therefore they can be limited, provided that they follow and are that such limitations are provided for in law and safeguards the essence of the rights and freedoms. And the court then questioned whether the principle of legality was maintained, and after having looked closer at Article 31 and 5 of the directive, it came to the conclusion that the principle of legality was fulfilled, and it then went on to ask whether the intrusion showed respect for the essence of the fundamental right guaranteed in Articles 7 and 8, and it came to the conclusion that it did not undermine the essence of the fundamental rights enshrined in Articles 7 and 8. I'm conscious of the time, so I'm just sort of speeding things up a little bit. Then it also posed the question of the objective of the general interest that was recognized by the European Union. And remember, we were talking about the general interest of the public and therefore the need of transparency. And this was something that in the motivations in the creation of the fifth AML directive was highlighted by the Commission, namely saying that the importance of promoting transparency for the economic and financial environment of the EU was essential, and therefore having the transparency in itself was a powerful deterrent. The court here made an interesting assessment, saying that, well, the principle of transparency was actually misinterpreted by the legislators, because the principle of transparency refers to institutional and procedural transparency covering activities of public nature. It is not for the purpose, and this, as it's guaranteed under Articles 1 and 10 of the Treaty of the European Union, as well as Article 15 of the Treaty of the Functioning of the European Union. So it can therefore cannot be considered as an objective and general interest capable of justifying the interference with the fundamental rights guaranteed in Articles 7 and 8, which results from the general public's access to information on public ownership. So essentially, the argument of transparency and the principle, and that having these registries open to the public would guarantee the principle of transparency, was basically shut down by the court. It then went and asked the question whether or not the interference of the issue was necessary and proportionate. And in its discussion, it came to the conclusion that, which I think is the more sort of interesting points made, namely that when looking at the seriousness and the interference against the importance of objective of general interest of preventing money laundering, terrorist financing, it must be held that although in view of the importance of that objective, it's capable of justifying even the serious interference with the fundamental rights enshrined in Article 7, the fact remains that combating money laundering and terrorist financing is a priority for the public authorities and for entities such as credit and financial institutions, which by reason of their activities are subject to specific obligations in that regard. So the argument of keeping these registries open for the public so that they can serve as sort of a substitute or a support in the fight against money laundering or illicit activities and sort of aid the government in research and making sort of disclosure by journalists and various NGOs and whatnot was not accepted by the court. And the court also pointed out that by replacing the requirement of a legitimate interest, providing for general public access to information on the beneficial ownership, was a considerably more serious interference with the fundamental rights guaranteed in Article 7 and 8, without that increased interference being capable of being offset by any benefits which might result from the latter regime of compared against the former regime in terms of combating money laundering, terrorist financing. Basically, that taking away the requirement of providing a legitimate interest and justifying it with that you had an online portal that you would have to subscribe to and that you would pay under, as was provided under the Article 35A, as well as providing an exemption option in Article 39, was not accepted by the court as a justification of limiting the fundamental rights guaranteed in Article 7 and 8. So in essence here, what the court did was that it gave, how can you say, the running point to the arguments made by the advocates of privacy, that, bringing back the question of are these rules really by providing public access to this type of information, are we essentially achieving the goals set out by the AML legislation? And the court here bluntly said no, it does not. With regards to the remaining questions that was posted in this joint case, because of the answer to the first question, the court did not see any reason in going into them, because once they had rejected the validity of the public access, there was no longer any question of discussing whether or not the definition of disproportionate risk and whether or not how you can apply for the exemption and so on and so forth. So some concluding remarks after having looked at this. We can therefore conclude that in the discussion between public disclosure of UBO information versus making UBO information public, the public disclosure is acceptable. That you cannot question, or that you cannot attack. However, making the UBO information public is not acceptable. Now, the general public interest of preventing money laundering and or terrorist financing is not sufficient in order to restrict individual rights and privacy, basically shooting that argument down. And the court shows that this particular court case shows that AML directive and directives, I would say, have fundamental problems, and that they are being, but however, these problems are overshadowed by the need to achieve and sometimes draconian policies. And also that this opens the possibility of even more cases being brought forward and what the future of AML legislation will look like. For example, there is something known as the Privacy First case in the Netherlands. This was actually a case that was initiated well before the European Court adjudicated this particular issue, but essentially it was brought up in the Netherlands, again questioning the validity of the UBO register as a whole, but with the point that the UBO registry in itself was a violation of fundamental rights to privacy and protection of data. This was rejected by the Dutch court, taken to the appeal, and the appeal court said that now we're going to wait to see what's going to happen in the Luxembourg cases. Interestingly, though, what they did was that as soon as the Dutch authorities found out that these particular cases had gone to the European Court, they suspended all the access to the UBO registries, waiting for the results of that case. So we're going to wait and see what happens there. The last case I'd just like to mention before I finish is KC 694. I'm not going to try to pronounce it because I'm not going there. But it's essentially a Belgian case with regard to what's known as DAC 6 directive that obliges lawyers who are subject to professional secrecy to submit and share information about their clients if they are participating in what's defined as sort of a tax scheme, and they have to therefore share this information with other intermediaries, which seriously puts lawyers and clients' relationship and confidentiality into question. And again, the European Court, using the same methodology as it did in the Luxembourg case, came to the conclusion, with regards to the issue of proportionality, that the fundamental role that lawyers who hold a fundamental role in the democratic society, and that professional secrecy also encompasses legal advice, and therefore any encroachment that is invalid in the light of Article 7 of the Charter. And it also stated that combating aggressive tax planning and preventing the risk of tax avoidance and evasion constitutes objectives of general interest recognized by the European Union. However, the relevant provision of the directive cannot be regarded as strictly necessary to attain those objectives. So on that note, I'd like to say that, in my opinion, I think that this particular case in Luxembourg was a very good case for those who are more prone to, on the side of privacy, and less positive for those who are, more adherence to strict and adherence to achieving money laundering goals and so on, no matter what the cost on the law would be. Thank you.
Thank you very much, Christian, for this thought-provoking suggestions and your presentation. There are a lot of issues arising from what you presented clearly, and this is really very recent, very new, and still difficult to grasp. I mean, we were expecting something of that type to come. We were discussing it for the past 2-3 years, if you remember. Christian, please mute yourself for the moment, because the sound is very bad. And so we were expecting this balancing exercise between various rights, particularly the right to or the duty of transparency vis-a-vis specific fundamental rights such as privacy, but not only. So this came, timely and handily. I have a couple of points which we can then open to discussion and which actually develop where you left it. So based on what Christian analyzed for us in details, the next question is, what happens with the legislative framework currently being developed at the EU level and currently being implemented in the member states, and not only in the member states? I mean, the UK, for example, would have a similar issue. So we all know that the EU institutions are currently working on the EU AML rulebook, which would include a new AML directive, as Christian pointed out in his first slide. Now, it's interesting that Christian was able to analyze for us this focus on the public interest, because there is a tendency in the AML legislation at the EU level, a little bit like what we saw with Klearchos before, to expand the scope of the professionals that are actually caught by the AML measures. And the idea, given the number of scandals that we have witnessed in the past couple of decades, the idea is even to catch journalists, but also particularly, people actually doing investigative journalism in particular, but also even third-party financing intermediaries that would even include jewelers, horologists, and goldsmiths. So there is this maximum list of professionals in every possible field caught by the remit or the web of AML legislation. And last but not least, as I said, there is this idea of catching even journalists, but also civil society organizations or NGOs. And when we see the current scandal of the Qatar Gate at the heart of Brussels, we actually see the role potentially played by some Brussels-based CSOs. So that is in addition to the complex structure or multi-layer structure of ownership and control structures available, as Klearchos already pointed it out, across the world. So my question to Christian, and that will open the floor, let's say, is what do you think, Christian, could be or will be the impact of this case law of the courts on the legislative framework in the Republic of Cyprus, but also in the further development of the legislative framework at the EU level? Thank you.
I think on the first question with regard to the effects, what it's going to have in Cyprus. Sure, we've seen that, and I don't want to sound too critical, but we've seen that there's been a stop in the public access of this type of information. But at the same time, there is no proper guidelines for how to obtain this information that the government has. So it has been the instruction that has been given is that you can apply to this to the registry, and if you can justify it with the fact that you're conducting your due diligence, you can get access to it. But there's a number of issues even there that raises questions, and it sort of comes back to my original call it I don't want to say criticism, but rather sort of my call for a wake-up call that when we're dealing with this types of it, because it is so intrusive of so many layers on the financial level, on the business level, on the private layer, and so on, we need to be extremely more diligent in how we address these types of rules, and especially as member states. I think what this case shows us is just because it's a directive does not mean that it's the word of God. You know, it has problems, it has flaws, it has, you know, it's right to criticize it. And I think that because of the situation that Cyprus found itself in after the 2013 financial crisis, we've been sort of swallowing these things along the lines without actually properly looking at it with a very, very, very sort of investigative eye and trying to plan how this implementation of what effects it would have on our Cyprus as the Republic of Cyprus. I think this is missing. So I don't see any particular drastic sort of change in that. I'm hoping that, you know, these types of cases and these types of discussions that we have here today will bring about a more of not to criticize it or be against it, but that it needs to be you know, a bit more scrutinized before just blindly implemented. On the European Union side, again, there is this, it's the problem of trying to achieve policy by all means possible, vis-a-vis by trying to gauge the effects that these rules will have. What I did not mention in my presentation was that in the preparatory works to the 5th AML directive, there was a lot of criticism that came out in various reports, both from within the Commission and outside of the Commission, saying that these rules were simply going too far and that they would not stand if scrutinized by the court. And they are right. And this is what now a lot of sort of legal professionals across Europe that have been shouting for these things for years are sort of now they have they've gotten wind in their sails. But you know, Europe is a little bit problematic in that sense that sometimes it policies dictates more than its common sense. but again, you know, I hope that this will lead to a bit more of perhaps a bit more self-reflection from the Commission side when implementing these types of rules.
Thank you, Christian. If you can mute yourself. Very good, thank you. I think Klearchos would like to react or reach out. And then, of course, the chat is open to anyone who would like to ask questions.
Thank you, Stephanie, and thank you, Christian. He spoke about the intrusive nature of some of the measures that are emanating from Brussels. I have to comment here, wearing my hat as somebody who was brought up in the Eurosceptic school of British politics, a school of thought that eventually emerged into the Brexit school of thought. Three points, they're interlinked. The first is that one needs to be wary about any measure that emerges from any institution that is unelected. And the European Commission, it's indirectly, or at least at the hierarchy level, indirectly elected through the member states. But we as individual citizens of the European Union have no vote in relation to the election of the appointment, rather, of the President of the European Commission and the other commissioners. They emerge from this rather secretive process that we as citizens have no direct impact upon, and that should put us on notice. Things that emerge, measures that emerge from secretive processes are inherently problematical, if not potentially dangerous, and that's something that should really trouble us. Now, elections are no guarantee that things will go well, but elections at least are the very heart of democracy. So that's the first thing I wanted to make. A lot of these EU directives and other measures are emanating from the sort of the Byzantine processes of Brussels. The second point, again, this is linked to Christian's point about the intrusive nature of these measures. They are in practice investing the state with powers that were never previously exercised or maintained or wielded, except in totalitarian regimes, or rather authoritarian regimes. So what we've seen with these measures, for potentially and ostensibly good reasons, is an imbalance between the state and the citizen. The power of the state has increased, the intrusion of the state on the citizen has increased, and those of us at the bottom of this structure are subject to this sort of increased weight that is in the hands of the executive branch of government. So that's the second thing philosophically that makes me quite uncomfortable with some of these reforms. And the third thing, this takes me back to my earlier comment, the lawyer-client relationship has been subject to sustained pressure. I'll go no further than that. It's been subject to sustained pressure. The lawyer was traditionally in a position in which the lawyer owed fiduciary, equitable, and other ethical duties to the client. The client reposed trust and confidence in the lawyer, and the relationship was built accordingly. What we've now had as a result of all of these measures, for ostensibly good reasons, is a change in the relationship and the very nature of the relationship between the lawyer and the client. At one level, the lawyer has to start with not on the necessarily on the presumption of innocence, although they should do. Everybody's entitled to the presumption of innocence unless and until proven guilty. But in practice, what are lawyers doing? Lawyers are trying to establish the cleanliness and the innocence of the client or the potential client as a prelude to taking on the client and acting for the client in relation to a potential matter. So the presumption of innocence is still our starting point in law, but in practice, lawyers are going about seeking evidence of cleanliness, which is almost a change in the way things are done. And the other thing that is now happening at the other end of the scale is that the lawyer is accumulating evidence on behalf of the state and potentially in exceptional circumstances handing over that information to the state if a reasonable suspicion, or whatever the current phrase is, in relation to the matter at hand. So my point is, yes, this legislation is to some extent absolutely necessary as a means of clamping down on economic crime and the evils that emanate from economic crime. But on the other hand, over the last 20 years or so, this legislation has had fundamental impacts upon concepts that we have held dear for centuries, including the democratic relationship between the citizen and the state, and the lawyer-client relationship in the office, or the courtroom, or the police cell, or anywhere else for that matter.
Thank you, Klearchos. I'm wondering whether we could go one step further and look back into the European Union. So in other words, reverse the process, not only having an outward process towards the member states, which is needed for the various reasons we have identified in the past 2 hours and a half, but reflects on the extent to which the EU institutions themselves, due to the lack of democratic skills and legitimacy, should be actually bound by similar processes. And this is something that seems to be largely absent, as we can see at the moment, that it is actually possible to raise allegations and suspicions of AML and corruption at the heart of the EU institutions. So I think that one thing that falls short of the AML regime at the moment is actually binding the EU institutions themselves into such processes, as opposed to, having a top-down approach towards the member states. What we need is probably a more horizontal approach, whereby both the EU institutions and the member states are held accountable for the proper implementation of what's happening and what is to come. That is, I think, one of the potential developments that we will need to think about. And the next development that we need to think about and picture, let's say, is anything that has to do with cryptocurrencies and other blockchain technologies, which is something we have not really covered tonight, simply because there is no time and there is no space. But this is probably something that requires a webinar on its own, given the length and the scope of current developments in the fields of digital currencies. So this is something else that should be in the pipeline and is actually being discussed at the EU level at the moment. I don't know whether there are any comments or any questions in the chat. I can't see anything. In the meantime, Christian, do you want to answer to any of the comments from Klearchos or myself?
Well, of course, I agree with a lot that Klearchos said, and we have today a situation where you are presumed guilty rather than presumed innocent. And this is where, I mean, when you read a lot of these sort of justifications in the preparatory works to the directives, and they talk about that, in order to, we need these types of measures in order to hunt criminals and to restrict legal professionals and to clamp down on this sort of very sort of again, I would say very scary sort of witch hunt of and it's you start asking the question, how real are these arguments actually? Because I mean, throughout my time as working in compliance, I have yet to see any proof that these measures have actually generated such big of an impact that they claim they have. Obviously, there are cases presented by various sort of organizations that the public interference and the NGOs and journalists have contributed to over 500 different arrests and the seizure of several millions of euros and dollars in funds and so on. That may very well be true, and I'm not disputing those questions, but it's a question of, is this really a job for the journalists to do, or are we now leaving this work to be done by private organizations, privately owned newspapers with their own agendas? Are these types of people that we should entrust with these types of measures? Personally, I don't think so. I don't take the argument that that journalists and researchers, are not picking on journalists in particular, but they are one of the biggest sort of arguments that they carry such a heavy weight that it would justify for this types of information to be open to the public. I don't see any justification for that. So I guess what I'm trying to say is that there needs to be a very higher level of perhaps of a soberness to what we're trying to achieve, and to really examine whether or not, you know, are these rules simply being implemented in order to give the appearance that the policy is being implemented, or are they actually contributing to it? I mean, another issue that, coming back to what Klearchos said, which I think is very important, is that now the report escapes me, but the point was made that lawyers in particular are the vanguards and are the gatekeepers of money launderers and so on and so forth, and therefore they should be targeted, you know, especially heavily. Well, to be honest, you know, I don't, you know, yes, of course you have criminals. You have criminals in all lines of professions. You know, the lawyers are not particular to that. If you look at if you compare the average sort of money worth of illicit activity conducted by lawyers and financial institutions, I think the financial institutions wins by a grand slam. Okay, but that is a job for the regulators. It is not a job for the private sector or for the sort of self-declared fourth government institution to come in and muck around in that. Then, if anything, you need to have better equipped and better educated regulators that can manage and implement these rules and so on. But these rules has to make sense. You can't just have rules and rules. What we have today is that we have rules and rules and rules and rules, and nobody really knows how to implement it, and therefore nothing gets done. And this is the level that we come to. So I think a bit more of a soberness to these types of rules are required. Will that be done at an EU level? It has a lot, I think, to do with the way that the European Union is structured, where pushing policies are. Now, having said that, and having worked in the European Commission myself, I know that a lot of the work that the European Commission has done is very thorough and very well balanced and very. But it, you know, it needs more attention, I believe, and if it's going to. And coming back to just as a final point, Stéphanie, on your comment on cryptos and financial tech, obviously these rules are continuously developing, and you know, as financial markets are developing, these rules are going to have to develop. And therefore, they are not static; they are not organic. What the rules were a couple of years ago does not apply today, and that's how it's going to continue. You know, and today it's cryptocurrencies, tomorrow it's going to be something different. But it is definitely and I surely agree with you that it's a topic for a completely different seminar. But I think that's the nature of this type of field. Compliance is as organic as even more today than perhaps it was 10 years ago.
Thank you, Christian. Klearchos, you wanted to add something?
Thank you. Couple of points. First of all, I don't know very much about cryptocurrency, so I'm going to limit my remarks to what's been happening in the Bahamas and the United States of America over the past few days. And I've been following this quite closely because it's an exceptionally interesting case. First of all, the FTX cryptocurrency empire appears to have imploded over the past few days. And I'm reading here from the US Department of Justice, US Attorney's Office for the Southern District of New York press release of the 13th of December 2022. So I'm choosing my words with exceptional care. Quote, the United States Attorney announces charges against FTX founder Samuel Bankman-Fried. Bankman-Fried has been charged in an 8-count indictment with fraud, money laundering, and campaign finance offences. That's a US Department of Justice press release of the 13th of December 2022. The US Securities and Exchange Commission have issued a press release on the same subject on the same date, 13th of December 2022, and the US the US House of Representatives Committee on Financial Services has published a string of documents to do with their hearing on what they call the exposing information on the collapse of FTX and founder Sam Bankman-Fried. That's a press release and set of documents dated 16th of December 2022. There is, now first of all, Mr. Bankman-Fried is entitled to the presumption of innocence. The case is sub judice, and therefore I'm not going to comment on it other than to draw to your attention that there is a Cypriot dimension to this case, which I'll let you find out on your own if you go and find the relevant documentation on the sources that I've given to you. And what that case therefore illustrates, if I won't go, I'll go no further than that. I'll just go no further than that. But what that case does demonstrate, and this is what I will say, is that one needs to treat the cryptocurrency sphere with exceptional care. The second thing that I wanted to say, which I didn't have time to during my presentation, goes back to what we Christian and I have been discussing, which is the implications of all of these measures that we've been discussing upon the rule of law and fundamental principles. Another fundamental principle that has been subjected to severe strain over the past year is the principle of equality before the law. It's one of the 8 cornerstones of the rule of law, according to Lord Bingham in his celebrated analysis of the rule of law in the Cambridge Law Journal of 2007. And those 8 cornerstones of Lord Bingham have been adopted by the Venice Commission of the Council of Europe. So these are not just English judicial principles laid out of court by Lord Bingham. They're principles that have been embraced by others, not least the Council of Europe. Now, the point of equality before the law is it's obviously not an absolute principle. It is a principle that's subject to exceptions in certain limited circumstances. But what we've seen over the last year is a full frontal assault on the Putin regime, which is one thing, and in my view, legitimate, especially in view of what's been happening over Ukraine. And that isn't to say that the Ukrainian government is led by angels. It clearly isn't led by angels. And that isn't to say that the prosecutor at the International Criminal Court should solely limit his investigation to what the Russians have been allegedly up to. In my view, the prosecutor at the International Criminal Court needs to adopt justice's blind approach and investigate all alleged crimes, irrespective of source. Having said all of that, the principle of equality before the law has come under severe strain because in practice, many ordinary Russian citizens and many legitimate Russian businesses have found themselves subject to the draconian measures that Prime Minister Johnson has referred to. And they've also found themselves subject to indirect forms of discrimination. Let me give you an example from England. One of the items that I've invited you to peruse after this webinar is a webinar that was organised by the Solicitors Regulation Authority, and it's been posted on YouTube. So it's a 1-hour video, an excellent 1-hour video with various different speakers. One of the questions in that webinar concerned what should a solicitor do if instructed to act for a Russian or potential Russian client. I'm paraphrasing here, of course. But what emerges from that video and from other sources that I've consulted is that in practice, even though everybody must have access to a solicitor, if they need legal advice or legal representation or legal services. In practice, what is happening in England is that some law firms are adopting a risk-sensitive approach to taking on new clients, and they're giving serious thought to whether or not, as a matter of policy, they should refuse to act for any clients who are citizens of Russia. Now, what on the one hand, freedom under the law, which is a principle that we in England cherish, gives solicitors the right to choose who to take on and who not to take on as a client. On the other hand, if they refuse to take on a client because that client is Russian or has Russian citizenship, that does raise questions under the Equality Act 2010 and the regulatory principles in the SRA Code of Conduct that deal with equality before the law. But even if a solicitor is willing to take on a client from Russia, or a legitimate or an apparently legitimate business from Russia, what a prudent solicitor might want to do is approach the professional indemnity insurance provider and ask the professional indemnity insurance provider whether the insurance policy of the law firm will extend to cover a case involving a client from Russia or a Russian citizen or a Russian company. And who knows, I don't know the answer to this question, who knows what the answer will be from the professional indemnity insurance company. If the professional insurance company says, no, we won't extend cover, then that Russian citizen or Russian business is deprived of legal representation or legal services or legal advice. So my point is, all of these measures that we are reading about on a daily, weekly and monthly basis, they are challenging fundamental principles that underpin the rule of law, from equality to the from equality before the law, as I've just discussed, to the lawyer-client principle of client confidentiality that I mentioned earlier, to what Christian was discussing about data protection, privacy, confidentiality, and so on. So I suppose that's one of the things that we've tried to bring across in this webinar, that anti-money laundering law, yes, must be obeyed, so must financial services legislation, but that obedience to the law, which is part of what the rule of law is about, should be supplemented by a critical mind which questions the legitimacy, as distinct from the legality, of the measures that all lawyers have to adopt. And I have to say that there is a comparable pressure on lawyers in the United States of America, and I was very pleased to see that the American Bar Association in recent months has taken a robust stand in support of traditional principles. I'm not a US lawyer, so I don't want to comment on that, but I do invite everybody to go to the American Bar Association website and the submissions, and read the submissions that the American Bar Association have made to both the US Senate and the US House of Representatives. This is a worldwide problem, or at least it's a problem that is afflicting the democratic world, and it needs to be addressed in a sensitive and democratic and rule of law friendly way. Easier said than done, of course.
On which note, thank you very much both for your input and for the amounts of knowledge and expertise you've shared with us, and the problematics that were raised. I suspect that we will be back in 2023 to comment and further analyze developments as we are dealing with, as Klearchos said, and also Christian, very dynamic issues that are not only legal issues, they are affected by politics and external shocks, such as wars and other crisis situations. So it will be our pleasure to return to that. In the meantime, I will please ask both Klearchos and Christian to have a last look at their slides and then send them over again. We will place them into the MS Teams folder to which everybody who is registered has access. And colleagues will be free to take the slides away and look at the wealth of resources that have been outlined in those materials. Now, I suspect we have not placed yet a feedback form into the MS Teams because I didn't have time to work on it with Katerina. Maybe Katerina has done it, but I don't think so. So we will place also a feedback form in the MS Teams and ask everyone if you could please give some feedback. Without any further ado, we'll release everyone. So let me take this opportunity to thank you again all and wish you a very happy festive season, end of the year. Hopefully we, all the professionals, will find some time to rest, as well as the students who are with us and who are having exams in the early start of 2023. So I would like to thank you all very much, also on behalf of the Larnaca and the Famagusta Bar Association representatives who had to go. And we have been very happy and very privileged to be with all of you. And we look forward to more interaction in 2023. Thank you, Katerina. Thank you, Kostas and Panagiotis for the support, and Melanie for the support in running today's webinar. So I will now stop the recording and you may all leave gradually.
Goodbye.
Thank you. Bye.